All right, we're on paragraph 22 talking about legal fees. It says in the event of any arbitration regarding this contract prior to or after the closing date, the court must award to the prevailing party all reasonable costs and expenses, including attorney's fees, legal expenses. And so if you get into a legal wrangle with somebody and you lose, you get to pay all these fees. And the winner takes all. If a dispute arises relating to this contract and is not resolved, the parties must first proceed in good faith to mediation. So mediators cannot impose binding decisions. Before any mediated settlement is binding, the parties must agree to the settlement in writing. And the parties will jointly choose the mediator and they will split the cost for the mediation. And nothing in this section prohibits either one from going ahead and filing a lawsuit and recording a lis pendens. The lis pendens is generally it means a lawsuit pending. And basically it's filed with the clerk and recorder in the county where the property is held. And it just says there's a lawsuit that's been filed. And again, it can be before or after the date of written notice requesting mediation. So anytime they want to, they can file that. Normally, the earnest money holder must release the earnest money following receipt of written mutual instructions signed by both buyer and seller. So this is what normally happens. If there's something that happens in the earnest money is going to be given back, both parties just sign that and then it's done. Then that allows the earnest money holder to release the funds to the buyer. However, in the event of any controversy, the earnest money holder has several options, and it's in its subjective discretion. It can wait for a proceeding between the buyer and the seller, so it can just hold the money till you guys work it out, or it can put it into a competent jurisdiction. So in other words, it can send it over to a court. Or 3, if there's a lawsuit filed, I'm going to let your attorney take care of explaining this part. Hopefully you'll never have that done, but I don't want to try and get in there and explain something that an attorney should really explain to you there. Now, there's several places, as we noted, that you've got a right to terminate, and if someone does that and turns in the written notice by the deadline, then the contract is terminated. If you don't turn in the request to terminate by the deadline, then you accept the matter, document, or condition as satisfactory, and then you don't get a chance to waive or to terminate. So if you're going to terminate, make sure you do it by the deadline. This is the entire agreement. Everything is in here. There's nothing else. No subsequent modification can be made except in writing and signed by both parties. So if you have an amend and extend or you agree to something else and it's in writing, that's the only way you can change this. Otherwise, this is the legal binding contract. Any document or notice must be in writing and effective when physically received by such party. That's if you do it by mail or handing somebody a piece of paper. It's legal as soon as they get it. Most people these days use electronic notice, and it says any notice may be delivered in electronic form at the address of the recipient by fax or email. And to do that, you can either email to the email address of the recipient or just send them a link to the website and instructions on how to access that information. That's commonly done. If there's any dispute under this contract, it's handled in accordance with the state of Colorado. This proposal will expire unless accepted in writing by buyer and seller by the acceptance deadline date. So generally at the very first line up there, it says acceptance of this contract must be made within the next 24 hours or by tomorrow at noon or whatever they say. And if they do have that with their signatures, then this document will become a contract. And both parties have an obligation to act in good faith throughout this whole thing. So we're going to stop that and wrap it up with one more section to come.